This presentation answers the question, what is a court-authorised will? It utilises the 2009 judgments of Re Charles and Re Fenwick, being the first two cases which applied the statutory provisions for a court-authorised will, along with the case of AB and CB and others, which was the first case to fall under Justice Palmer's preemptive capacity category. A court-authorised will, as provided by Chapter 2, Part 2.2, Division 2 of the Succession Act 2006, New South Wales, confers power on the court to authorise the making, altering or revoking of a will or part of a will on behalf of a minor or a person who does not possess testamentary capacity. A court-authorised will is properly executed under Section 23 if it is made in writing and signed by the registrar and sealed with the seal of the court. A statutory will may be executed pursuant to Section 23 even if the person who the will was made on behalf of has since died. In accordance with Section 5, Subsection 3 of the Act, a will made by a minor will be deemed valid if it were made pursuant to Section 16 of the Act. A minor is defined under Section 21 of the Interpretation Act as a person under the age of 18. Section 5, Subsection 2 provides an exception that a will made by a minor not under Section 16 will also be valid if the minor made the will in contemplation of marriage or is already married. An application for an order under Section 16 may be made by the minor themselves or on behalf of a person or by a person on behalf of the minor. Prior to making a court-authorised will on behalf of a minor under Section 16, the court must be satisfied that, pursuant to Section 16, Subsection 4A, the minor understands the nature and effect of the order to be made and that the order accurately reflects the intentions of the minor. Section 16, Subsection 4A thus excludes minors who lack testamentary capacity. However, Section 18, Subsection 4 provides that a court-authorised will may be made under Section 18, Subsection 1 on behalf of a minor who lacks testamentary capacity. In the case of the Secretary Department of Family and Community Services and K 2014, Justice Lindsay stated that this power is discretionary as defined under Section 9 of the Interpretation Act, in that it may be exercised or not. A person who wishes to apply for an order under Section 18 must firstly seek leave of the court under Section 19, Subsection 1. Section 19, Subsection 2 sets out a non-exhaustive, non-rigid checklist of the information which the court requires before leave will be granted. This checklist is not rigid, and the court may apply a dispensing discretion if the information is not relevant to the case, or if the information will have no bearing on the decision of leave. When exercising the dispensing discretion, the court must do so with regard to two primary considerations. Firstly, what is in the best interest of the incapacitated person and of those who have a proper claim to his or her testamentary estate. And secondly, what will facilitate the just, quick and cheap resolution of the real issue in the proceedings. Leave will be granted if the court is satisfied that the matters under Section 22 have been made out. Under Section 22, all 5 categories must be addressed, and therefore the court cannot exercise its dispensing discretion under Section 22. The 5 matters include that there is a reason to believe that the person in relation to whom the order is sought is or is reasonably likely to be incapable of making a will, that the proposed will is reasonably likely to be one that would have been made by the person if he or she had testamentary capacity, that it is appropriate for the order to be made, that the person seeking leave is an appropriate person to be seeking leave, and lastly, that adequate steps have been taken for a person with a legitimate interest in the application to be allowed representation. Justice Palmer stated, an order is appropriate under Section 22C if the court is sure that the incapacitated person's expressed wish is known, if known, is not irrational or the product of pressure or influence. The court may in determining the Section 22 matters, exercise its investigative power under Section 21B, or ignore the rules of evidence pursuant to Section 21C. In the case of Reed Charles, Justice Palmer listed 3 circumstances in which the criteria under Section 22, subsection B provides for. Firstly, cases involving a lost capacity, which involves a person who has lost testamentary capacity and as a result is no longer able to make a later will or codicil their will. The second circumstance involves nil capacity, in which the person never actually held testamentary capacity. Lastly, preempted capacity cases, which involve minors who held an extent of testamentary intention but have since lost the capacity to hold that intention. Justice Lindsay, in the Secretary Department of Family and Community Services and K, stated, however, that whilst these 3 categories provide useful insights into the operation of the court's will-making power, they should not be taken as a substitute for the text of the legislation itself, and must only be taken into account with consideration of the protective jurisdiction under the Act. In the case of Reed Charles, 2009, this involved an 11-year-old boy who suffered irreversible brain damage at 4 months old. In 1998, Charles was removed from his parents' care and orders were made placing him in the care of the Minister for Community Services. In 2000, he received an injury compensation award of $50,000 to be held on trust by the New South Wales Public Trustee until he turned 18. Charles's life expectancy diminished and an application was made by the minister, seeking that the court grant leave under Section 19, subsection 1, and that he be able to apply for a court-authorised will for Charles under Section 18, which would leave his estate to his sister with gifts to 2 charities which had cared for disabled children. The purpose of the application being to avoid his estate going to his parents on intestacy, as evidence showed his brain damage was consistent with shaken baby syndrome caused by his parents. This was despite the fact that his parents denied ever having caused the injuries, or the fact that they had never been charged with the injuries. In assessing the 5 categories under Section 22, Justice Palmer began by classifying Charles's case as a nil capacity case, as he never had and never will have testamentary capacity. This is because his medical conditions were so severe and he had suffered them at such a young age. Charles's parents were named as respondents and were notified as to their entitlement to representation under Section 22E. However, they did not wish to seek representation, nor did they object to the proposed will, and they did not attend the hearing. Evidence was provided attempting to show what Charles's intentions would have been likely to have been if he now possessed testamentary capacity. Justice Palmer, however, rejected this, stating that he declined to perpetuate this fictitious test and instead adopted an objective test in assessing Section 22B. His Honour reasoned that it was not necessary to make a positive finding as to whether Charles's parents had actually caused his injuries, but nevertheless he was satisfied that the circumstances undeniably raised suspicion against them, due to a history of reports about Charles's well-being when he was an infant in their care. Accordingly, His Honour held that there was a fairly good chance that a reasonable person faced with Charles's circumstances would not choose to die intestate, leaving his estate to pass on to his parents. The court went on to find that it was highly probable that a reasonable person would give the whole of his estate to Charles's sister with the gifts to the 2 charities. The court took into account, for the purposes of Section 19, subsection I, of the possibility that Charles's carer may have a claim over his estate, as she had devoted her full-time care to Charles for nearly his entire life. However, The carer had expressly disavowed any wish to share in Charles' estate. Justice Palmer stated that but for this express disavowal, he would have required that provision be made for her in Charles' statutory will. But notwithstanding this, due to her express disavowal, His Honour was satisfied that there was no person who would be eligible for a family provision claim. The Court, in exercising its power under Section 20, subsection 1, was satisfied that the evidence supporting the Minister's application for leave would not change in the foreseeable future, and so leave was granted, and the Court immediately made an order under Section 18 approving the Minister's proposed statutory will.
Thanks, Cara. I will now explore preempted capacity cases. Firstly, we will look at the leading case authority of AB and CB. In this case, a mother applied for a court-authorised will on behalf of her daughter CB, who had become severely incapacitated and legally incapable of making a will at the age of 16 as a result of an acquired brain injury. This was a preempted capacity case, as prior to the accident, CB had held the capacity to express wishes regarding testamentary disposition, but now she would never regain testamentary capacity. In accordance with Section 19.2, the mother provided evidence of her daughter's lack of testamentary capacity and an estimation of the size and character of the estate. The Court held that it would not be appropriate under Sections 22E and 25 of the Act to appoint a separate representative for CB, as there were no conflicts of interest and no one would contest the estate. The mother's proposal was found to represent the actual intentions of CB if she were now of testamentary capacity, according to Section 22B of the Act, and reflected what a reasonable person in CB's position would do to acknowledge the extent of her mother's care, which will continue for the rest of CB's life. We will now move on to lost capacity, which we will explore through the leading case authority of re Fenwick. The case concerned Robert Fenwick, who was aged 60 when he lost testamentary after suffering a severe head injury at work. However, he had made a will 10 years before. His will provided for his estate to go to his brother, but if his brother did not survive him, then it is to be vested in his children. However, he never had any children and never would. Fenwick's brother sought that a statutory codicil be made under Section 18 to Fenwick's last will, to avoid an intestacy and consequently Fenwick's estate being vested in the Crown, as all of his relatives were older than him or had life-threatening medical conditions. Accordingly, Justice Palmer was satisfied, in light of what is known of his relationships, history, personality, and the size of the estate, that if Fenwick had testamentary capacity, it is reasonably likely that he would have made the proposed codicil to make his cousin's children his ultimate fallback beneficiaries. Through these cases, Justice Palmer has provided guidance as to how to test intention under Section 22B of the Succession Act. His Honour concluded that it is fundamental to start with a clean slate and to consider the section in light of the problems the legislation seeks to remedy, bearing in mind that legislation of this kind should receive a benevolent construction. We will now consider intention in lost capacity cases, nil capacity cases, and preemptive capacity cases. In lost capacity cases, the Court is concerned with whether any actual intentions or wishes have been expressed. This is measured by a reasonable likelihood, which, in simple language, means a fairly good chance that the person would have made the will if they held testamentary capacity. It is important to utilise the subjective intention of the incapacitated person. Comparably, in nil capacity cases, the Court utilises an objective test of likelihood only, as it is impossible to search for any actual or subjective intention. To determine this, the Court employs a reasonable person test. In a preempted capacity case, Justice Palmer advises applying both a subjective and objective considerations, such as history and relationships. Secondly, the court is expected to contemplate whether the teenager was capable of expressing testamentary intention before becoming incapacitated. Then it needs to consider whether it is reasonably likely that intention would be expressed if he or she had testamentary capacity. From these cases, Justice Palmer provides observations on future practice and procedure. Justice Palmer observed that in relation to future applications for court-approved wills, it is desirable that they should be dealt with by the court as quickly and with as little expense to the parties as possible. Accordingly, His Honour suggested that in straightforward and unproposed cases, such as the above cases, there is no need for the applications to be heard in open court, or for counsel to appear and make submissions. Instead, such applications can be dealt with on the papers by a judge in chambers, pursuant to Section 71D or Section 71F of the Civil Procedure Act, which advocates for the quick, just and cheap resolution of proceedings. Further, Justice Palmer indicated that there is no need for publications of reasons for a decision made in chambers in straightforward, uncontested applications for a statutory will, as there is no public interest in publishing reasons for judgment in such cases, as the issues in such applications only concern immediate family members. We will now move into a quiz to test what you have learnt from our presentation. It entails 5 questions from each of the topics covered in this presentation. Firstly, we will look at court-authorised wills. The first question is, what are the elements for a properly executed court-authorised will under Section 23 of the Succession Act? I will now give you a few moments to think about your answer. The correct answer is, under Section 21(1)(a), that the will be made in writing, and under Section 21(1)(b), that it be signed by the register and sealed with the seal of the court. We will now cover testamentary capacity. Can you please identify and explain the 3 categories of testamentary capacity Justice Palmer described in Re Charles? That's right. There is lost capacity, which is where the incapacitated person is an adult, has formed relationships, has made a valid will before losing testamentary capacity, and is now said to have expressed some testamentary intention regarding the circumstances sufficient to warrant an application for a statutory will. Then there is nil capacity, which describes individuals who never had and never will have testamentary capacity. Finally, there is preemptive capacity cases, where the incapacitated person is still a minor but has lost testamentary capacity at an age which he or she has formed relationships and had, or could have reasonably expected to have had, a fairly good understanding of rulemaking, intestacy, and their consequences. Now we will test lost capacity. Can you please explain how to interpret Section 22B of the Succession Act when dealing with a lost capacity case? Yes, that's correct. There's 3 elements you need to consider. The court's concern is whether there was any actual intentions or wishes that have been expressed. This is determined by a reasonable likelihood, which we know means a fairly good chance that this person would have made the will if they had held testamentary capacity. And finally, we use the subjective intention of the incapacitated person to make this decision. Our next question is, how did Justice Palmer reason his decision in Charles? His Honour thus reasoned that there was a fairly good chance it is likely that a reasonable person faced with the same evidence would not intend for his estate to pass on to Charles's parents. The court granted leave and under Section 20, subsection 2, immediately made the order proposed by the Minister as the circumstances were unlikely to change in the foreseeable future. The last question is, can you please explain what the court held in CB and AB? That's exactly right. The court held that it would not be appropriate under sections 22E and 25 of the Act to appoint a separate representative for CB, as there were no conflicts of interest and no one would contest the estate. The mother's proposal was found to represent the actual intentions of CB if she were now of testamentary capacity, according to section 22B of the Succession Act, and reflected what a reasonable person in CB's position would do to acknowledge the extent of her mother's care, which will continue for the rest of CB's life. Thank you for listening to our presentation, and I hope you all learned something. Thank you.